Assalamualaikum warahmatullahi wabarakatuh. Today we are going to presenting one of the case BK Fleet Management Sudan Berhad against Stanson Marketing Sudan Berhad under illegality. And my name is Isharadia with Yoma Yusuf, and my metric number is 231X038, and my friend is.
And my name is Hurul Ain Hashashah Najwa binti Jafar with metric number 2314620.
The appellant is a company that provides fleet management service, including supplying and maintaining vehicles. And the respondent is the company involved in sales and distribution of bakery goods under the brand High Five. BK Fleet Management Sudan Berhad entered into 4 agreements with Stanson Marketing Sudan Berhad to provide fleet management services for 179 trucks used for distribution of Stanson's bakery goods. The trucks were registered under Stanson Marketing's name, but BK Fleet Management retained the beneficial ownership. When Stanson Marketing defaulted in paying for the services under the agreement, BK Fleet Management sued for 6.5 million ringgit in unpaid fees and the return of the trucks. But later, Stanson Marketing counterclaim, dispute the debt, and also sought an order that the BK Fleet Management to surrender the registration card for the trucks after cancelling its endorsement of ownership on the card. After a trial, the High Court dismissed both the claim and the counterclaim on the ground the agreement were void ab initio.
So now, let's move on to the arguments by both parties. Firstly, on behalf of the appellant, the learned counsel submitted that the learned High Court judge had erred in facts and in law in failing to consider and take into account that the agreements being taken between the parties had not contravened with any provisions under the Commercial Vehicle Licensing Board Act 1987. This is due to the respondent was the registered owner of the trucks as required by the Act, and the appellant was the beneficial owner for all the trucks. In addition, it is also common in Malaysia where in a hire purchase arrangement, the hirer or owner hires out a vehicle to a hiree under the hire purchase arrangement, and that the hiree uses the vehicle to carry his own goods operating under permit C license. The hiree who is not the owner is allowed to operate the vehicle under permit C license. Therefore, they argued that the learned judge failed to consider that the arrangement between the parties did not contravene any provisions under the Vehicle Licensing Board Act 1987, and hence Section 24 of the Contract Act 1950 is deemed not applicable in this situation. Therefore, the parties were bound by the contract that they had legally entered into. Besides, on behalf of the plaintiff, it is also argued that even the arrangement were found to be void as being illegal, the restitution could be had by the plaintiff under Section 66 of the Contract Act 1950. Next, we move on into the submission by the respondent. Firstly, in respect of the ownership, the respondent claimed that it is the owner of all the trucks specified in the schedule to the 4 agreements, and that almost all of the trucks in question are registered in its name. According to the respondent, Clause 10 of the first agreement only gave the appellant a first right or option to purchase the trucks upon completion of the first agreement for the consideration of 100 ringgit per truck. As for the remaining 3 agreements, Clause 9 gave the appellant a similar option, but this time at 1 ringgit per truck. The respondent further claimed that at the time of the filing of the claim, the options were not accessible yet by the appellant. Consequently, the appellant was not entitled to the relief sought. Secondly, the respondent also argued that the trucks were utilized to carry the respondent's goods, for which the appellant was prohibited from providing the fleet services or supplying the trucks for hire without first obtaining the requisite carry license issued under the Commercial Vehicle Licensing Board Act 1987. Since the appellant did not have those relevant licenses, the first right or options were tainted with illegality, unlawful, and unenforceable. And now, for the issues in this case are, firstly, is to ask whether High Court right to hold agreements void ab initio and unenforceable under Section 24 of the Contract Act 1950, and secondly, whether the appellant could not obtain any relief under Section 66 of the Contract Act 1950. The first issue, and based on the majority decision, the agreement were declared void ab initio and unenforceable under Section 24 of the Contract Act in 1950. The court held that based on the evidence presented, the appellant and respondent structured the agreement deliberately to circumvent the requirement for an A license under Section 14 Clause 2 Clause A of the Commercial Vehicle Licensing Act 1987. This was evidenced by the appellant's own witness admitting that the trucks were registered under the respondent's name to avoid obtaining the A license, which would have increased the rental cost. Hence, such intentional circumvention was deemed to against public policy and defeat the licensing provisions established by the Commercial Vehicle Licensing Board Act 1987. Therefore, as both parties were fully aware of and participated in this illegality, the contracts were rendered void ab initio and unenforceable. For the ratio decidenda, Section 24 of the Contract Act 1950 explicitly prohibits agreements that are illegal or contrary to public policy. Hence, circumventing the Commercial Vehicle Licensing Board Act 1987's licensing requirement constitutes a direct violation of public policy, which will render the agreements to be void. And now we can see the supporting cases as mentioned in the case of Sajjan Singh and Sardar Ali, where the Privy Council held that an arrangement to circumvent haulage permits under the Road Transport Ordinance was illegal. Similarly, the agreement in this case were void as they aimed to avoid obtaining the proper air license under the Commercial Vehicle Licensing Board Act. Besides, as in the case of Singma Sawmill, the Federal Court held that contracts illegal in themselves are void and unenforceable. And now let's move on to the second issue, and based on the majority decision, the court rejected the appellant's claim for restitution under Section 66 of the Contract Act 1950. This is due to Section 66 applies only to agreements that are discovered to be void after being entered into without knowledge of their illegality. In this case, both parties were fully aware of the agreement's illegality at the time they were executed. The appellant knowingly structured the agreements to circumvent the licensing requirements of the Commercial Vehicle Licensing Board Act, as evidenced by the conduct and admissions. Consequently, the plaintiff could not rely on Section 66 to recover any benefits or claim restitution, as the agreements were void ab initio due to illegality. Hence, for the ratio decidenda, it can be seen that Section 66 does not apply to agreements that are void due to illegality if the parties were aware of the unlawful nature of the contract from the very beginning. This means the provision only provides relief for agreements that are later discovered to be void. For the supporting cases, as in the case of Pipmoy, it says that Section 66 does not apply when parties knowingly entered into an illegal agreement, and as in the case of Lim Karbi, the court emphasized that contracts illegal on their face cannot be enforced and restitution cannot be granted for such contracts. Now, let's move on into the decision part. Hence, it was held that the learned High Court judge did not err when deciding the agreements void ab initio and unenforceable under Section 24 of the Contract Act 1950. Secondly, this was held that the appellant could not obtain any relief under Section 66 of the Contracts Act 1950. Next, for the analysis of the case. Why is this case is important is because, firstly, to protect public policy. This case shows how the court enforced Section 24 of the Contract Act 1950, which makes contract void if they go against public policy. As in this case, the agreements were structured to avoid getting the required air license under the Commercial Vehicle Licensing Board Act 1987, which was seen as an attempt to bypass the law. Hence, the court made it clear that contracts must follow the law and cannot undermine it. Secondly, to highlight illegal contracts. This case reminds us that contracts with an illegal purpose are automatically invalid. Here, both the appellant and respondent knowingly created an agreement to avoid legal licensing requirements. Thirdly, to limit on claiming restitution, the court also clarified that Section 66 of the Contract Act 1950 cannot be used to recover losses if both parties knowingly entered into an illegal contract. Hence, this is a reminder that the law will not help anyone trying to benefit from an unlawful agreement.
Okay, now let's moving on to the next analysis, which is, does it relate or strengthen the principle of contract law? And the answer is yes. The BK Fleet Management Sedang Berhad and Stanson Marketing Sedang Berhad case significantly relates to and reinforce several principles of contract law, particularly those concerning illegality. Okay, now here's how the case relate to the Contract Act. In the Section 24 of Contract Act 1950, the contract with unlawful purpose or those intended to circumvent legal requirement are void. The ruling emphasized that court will not enforce agreements that are void ab initio due to illegality, even if both parties knowingly entered into the arrangement. This strengthened the principle that both parties' complicity in an unlawful act precludes them from seeking judicial relief. And as saw in Section 66 of Contract Act 1950, the court clarified that restitution under Section 66 is only available if a contract is later discovered to be void. However, in this case, as both parties knowingly entered the agreement with unlawful purpose, Section 66 was deemed inapplicable. This reinforces the principle that restitution cannot be claimed when parties knowingly violate the law. And for the comparison with other similar cases, in the case of Public Bank Berhad against Reality City Berhad, and the Court of Appeal endorsed the UK Supreme Court's decision in Battle against Mirza, adopting a flexible approach to illegality in contract. The court emphasized structured judicial discretion when the illegality defense is invoked, moving away from the strict rule-based approach. And for comparing these two cases, in BK Fleet Management cases, was adopted a strict rule-based approach, finding the agreement void ab initio due to their unlawful purpose of circumventing licensing laws. However, in the case of Public Bank, the case was advocated a discretionary approach where courts balance factors such as the proportionality of denying relief, public interest, and the relative culpability of the parties. So for their relevance, such as that BK Fleet Management case might have been decided differently if the court had considered a more flexible balancing approach rather than an automatic voiding of the contract. And last but not least, the Maple Amalgamated. The federal court clarified that the agreement breaching statutory provisions are not automatically void for illegality unless clearly intended by the statute. The court favored interpretation that uphold the validity of commercial transaction, emphasizing the importance of commercial sense in contractual dealing. And to compare between those cases, BK Fleet Management agreement were deemed void for breaching the CVLB Act's licensing requirement, which were treated as mandatory. And for the Maple Amalgamated cases, the court emphasized that not all breaches of statutory provision automatically render agreement void, unless expressly intended by the law. For the relevance, if the BK Fleet case applied this reasoning, the court might have validated the agreement while penalizing the specific statutory non-compliance separately. And to be concluded, in these cases, the agreement were voided for circumventing licensing laws under Section 14 close to Substitute A of the CVLB Act, and the courts found agreement void under Section 24 of Contract Act 1950 due to the public policy violation. And the last one is appeal from the appellant was dismissed. Both case and the counter claims rejected.
I think that's all from us. Thank you.